In this case, the city of Charleston, more specifically, um, uh, the Medical University of South Carolina, instituted a program because it was concerned about the number of children who were being born to pregnant women um, whom were addicted to cocaine. So the hospital staff began conducting urine screenings on these pregnant women and referring those women who tested positive for counseling. The case manager of the hospital determined that there was probably a better way of doing this and began directing the women to the city police, and then they would be prosecuted for child abuse. The theory basically being that this would be a disincentive. It does not take a a bright person to understand that most of these women did not understand and were not told that A, this test was being conducted, or B, even if they were told the test was being conducted, their assuaging to the test was not consent to the test being used for law enforcement purposes. So the issue in this case is whether this test um, is basically a search under the Fourth Amendment. Uh, in a very strong opinion, Justice Stevens concludes that this search, well, first off, it was a search, and this search was unconstitutional because the women did not engage to this search with fully informed consent. And that even though the hospital was acting for a as a private entity when they were engaging in the test, that they were engaging in simultaneously a state activity when they turned over the results of the test to local law enforcement. And so they were acting as agents of the state when they were engaging in this. And when the state seeks to do a search, they need to have probable cause to engage in the search. And in this circumstance, probable cause was never assessed. Um, there wasn't a court issuing a warrant, and therefore these searches are inherently unconstitutional. The issue I take with this case is the dissent, which is Justice Scalia, which is also joined by Chief Justice Rehnquist and Justice Thomas. The reason why they dissent is because they deem that there was absolutely no search involved, and search in terms of the legal nature of a search. And the reason to this is because um, the search was based on urine, and urine is a waste product. And as such, individuals regularly dispose of it. And as individuals regularly dispose of a waste product, one cannot think it as being um, a private thing. That it would be no differentiation from throwing something in a trash can in the public and then getting upset if that evidence was then used to tie you to a crime. The stretch of logic that this dissent takes is impressive. Um, but it goes worse than that because Justice Scalia says that the search in question isn't even problematic if individuals were coerced into giving their samples, because the important distinction between the hospital as a private entity and the police force was notable. If it was medical professionals coercing someone to take the test, it wasn't the state coercing them, and that provided the state a degree of protection because the women were giving up the samples as a form of medical care. Um, the city of South Carolina, or not the city of South Carolina, the state of South Carolina has a number of problematic histories regarding pregnancy, childbirth, and the actions that the state takes to attempt to stop those whom are undesirable from having children. So literally the next case we do, an entirely different section, Buck v. Bell, also originates in the state of South Carolina. And you will see that the history that takes place in this case, which started in 1988 and continued on, finally ending in 2001 with a decision in the Supreme Court case, has a long legacy of history within the state, dating as far back to the early 1900s, and much of it was based primarily on the eugenics movement in the United States, which was exceedingly popular at the time, yet has its roots in horribly wrong science. So the decision in this case goes in the right direction normatively, but it is yet another example of people of color being criminalized and laws being skirted around in creative ways that denies individuals their constitutional rights.